The next session will explore, in fact, one of the points that we raise, which is force majeure, but specifically in the context of the CISG. And for that session, our moderator will be Mr. John Rooney. And although at the risk of making him laugh, and hopefully not wins, because I am sure he has heard it before, this is not John Rooney, the footballer, but John Rooney, who unfortunately, like a lot of us, and as penance for his many sins, is but a lawyer. Mr. Rooney.
Thank you very much. As was mentioned, the title of this session is Force Majeure under the CISG. I begin by saying that those who are familiar with the CISG know that the term does not appear in the instrument. So what we are doing is dealing with the general concept of force majeure in the context of the CISG. We're also going to look at Unavoidability. We're going to look at recent developments with respect to changes in the law of obligations in France, dealing specifically with the subject. To deal with the subject, Christopher has put together a really talented panel. What I'm going to do is briefly introduce the panel members now. Then each will proceed to their presentations. Our three panelists are Dr. Edgardo Munoz, Sandra Friedrich, and Rose Rameau. A truly talented and diverse panel. Dr. Munoz is a member of the law faculty at the Panamericana University in Guadalajara, Mexico. He frequently, in that context, contributes in specialized publications and discussions forums. He received his Bachelor of Law degree from the Universidad Iberoamericana in Mexico, master's degrees from the University of Liverpool in the United Kingdom, and the University of California at Berkeley. He holds a doctoral degree from the University of Basel in Switzerland. Besides his academic commitments, he practices in the area of international contracting and arbitration, sits as an arbitrator in international forums, and represents clients in commercial and sport proceedings. Sandra Friedrich, our second presenter, is a lecturer in law and director of the International Arbitration Institute and the White and Case International, New York, focusing on complex commercial and investment arbitration proceedings as well as litigation. She teaches courses on drafting complex arbitration clauses as well as transnational litigation and international arbitration with a European nexus at Miami Law, oversees the International LLM Practical Program at the university as well. In the past, she has also taught courses on international business transactions, European Union law, and German law at the University of Miami, co-author of several publications on international commercial and investment arbitration. She is admitted to the New York bar. Before she had obtained her JD from the University of Miami, she received a Master in Law from the University of Paris, Panthéon-Sorbonne, and an LLM degree with a specialization in international economic law from the University of Cologne and the University of Paris as well. Rose Rameau is a fellow of the Chartered Institute of Arbitrators. She is a partner at the Rameau law firm based in Washington, D.C. She is a former Fulbright Scholar, visiting professor in international arbitration at the University of Ghana Faculty of Law. She is an international arbitrator, mediator, and dispute resolution counsel. Focuses her practice on investor-state disputes and commercial arbitration, counsels governments and investors on concession agreements leading to international disputes in the oil and gas industry, including investment treaties before courts and tribunals. She has been appointed sole arbitrator in commercial contracts between African nationals and foreign investors, as well as a co-arbitrator in investor-state disputes. She's a member of the International Arbitration Institute in Paris, also an arbitrator on rosters of the British Virgin Islands International Arbitration Center, the Cairo Center, and other arbitration centers as well. She is an ICC court member representing Haiti and a member of the ICC Commission on Arbitration and its task force addressing issues of corruption in international arbitration. She is also on the advisory board of the Jamaica International Arbitration Center and a board member of Arbitral Women. With that, I will pass the microphone to Professor Munoz, who will begin his discussion, which is going to focus on Article 79 of the CISG. Professor?
Thank you, John Rooney. It's a pleasure to be here with you. Thank you so much, Christopher Malcolm, for putting together this wonderful conference, seeing some colleagues from the Caribbean area, but also from all over the world. As John mentioned, my duty here is to explain this provision in this, what we have called a very successful international private law treaty, which is the CISG. Today has more than 90 member states. Within those member states, there are the major jurisdictions. Big missings are still England, Jamaica, of course, and India. But I think this is a good forum to talk a bit about the provisions and how they work perfectly well in today's world. As you know, different circumstances surround today's international trade that obviously were not expected by many of us at the end of last year or even at the beginning of this year. The COVID has brought or has forced some cellulose manufacturers to shut down factories. We have seen breakdowns in supply chains, increased cost in performing contracts, and also some markets for buyers have even disappeared. So how can we, from a legal perspective, address this change in situations? Well, you have been talking about doctrines as force majeure, hardship before this panel, but one of the instruments and the provisions that would be relevant in today's international trade sale of goods would be Article 79. Article 79 does not include provisions, concept of force majeure or hardship. It talks about impediments. Someone in the chat have already pointed that out. But actually the CISG would be only the supplement to what the parties have agreed in their contracts. So the starting point to see what would be the solution to handle this change in circumstances, these difficulties, impediments, or hardship to perform contracts would be the contract itself and any hardship or force majeure clause that is inserted in it. We know that the ICC has provided two models for these situations, one in 2003 and a recent one this year, very timely, by the way, and some contracts have similar clauses, and that would be basically the starting point. Now, these situations start becoming relevant depending on which of the parties have not performed his obligations. As you know, the risk price and the time of delivery is particularly important in this regard. If the seller has not delivered the goods on time and at the place agreed, because he's been affected by changes in circumstances after the conclusion of the contract, well, he will have to bear that risk unless he is exempted from performing the contract, and we will see what to be exempted means. So Article 79 CISG states the following: a party is not liable for a failure to perform any of his obligations if he proves that the failure was due to an impediment beyond his control and that he could not reasonably be expected to have taken the impediment into account at the time of the conclusion of the contract or to have avoided or overcome it. So you have three requirements. It must be about different circumstances, an impediment that is beyond control of the parties. It should also be an impediment that was not foreseeable. The parties could not have reasonably, and that's an important adjective, reasonably expect to have taken into account. The term reasonably is also included in the new ICC clauses, mirroring what the convention already said. And even when the impediment is already there, couldn't have been foreseen, in order to be exempted under these provisions, the party affected by the situation cannot or should not be able to avoid it or overcome it. So, for example, in the typical case where the seller of commodities cannot deliver because he lost them in the way to the point of delivery, usually that would be because whatever reason you want, act of prince or natural disasters, it is most likely that he would meet the first two requirements. It was an impediment before his control. He could not have expected it, but as he is selling something that is generic, he is able to overcome that impediment by outsourcing the same generic goods from a different supplier and then deliver perhaps a bit late. The question now is whether the current situations that we are facing due to the COVID constitute an impediment under Article 79. Article 79 does not, as I said before, distinguish between force majeure and hardship. Hardship is covered by the type of impediments that are dealt with in Article 79. That is basically the general understanding in case law and scholarly writings. The question most relevant for hardship under this provision is the standard required to consider that hardship has become an impediment, right? So if we go back to the examples I gave at the beginning, shutdown of a factory due to special government laws prohibiting the gathering of a given number of people in certain place, or an export prohibition, for example, of masks, or failures in the supply chain because different carriers have stopped activities, increased costs for performing because basically some of the inputs for the merchandise would need to be brought from a different place. All these things have happened already now, and some of the contracts that were concluded before the beginning of this year have been affected by those type of circumstances, those changes. So I am not giving an answer here on whether each of those examples constitutes an impediment or only an increased cost that may be considered hardship because it's excessively onerous or has made the obligation excessively onerous to perform. But that is what the adjudicator in today's world will need to look at. And so I think that the provision in Article 79 is well designed to handle these cases. In case there is a real increase in the market price for the goods or on the obligation of the goods and the seller cannot perform, there would be arguments to exempt him from performing. However, we need to take into account that several case law has already stated, CISG case law has already stated that an increase in 200% in the market price could not be enough to exempt a party from its obligation to perform in particular situations. For example, when the type of market is a speculative one and the seller is assumed to have assumed the risk of this price increase or taking the risk of the price increase. Now, what are the remedies for general force majeure under the CISG for those type of impediments that does not increase the cost, but that prevent a party from performing? I'm talking about, for example, export bans, closure or prohibition of selling goods or producing goods that we are seeing now, or that we saw at least in some countries for some time. Well, the remedies are the exemption from damages according to Article 79. A party who is affected by the type of impediment stated in that provision is not liable for damages. Although this provision does not state so, the party affected by the change of circumstances cannot be forced to perform. This means that the remedy of a specific performance is also barred. It's also not available, at least during the time the impediment exists. What the other party can exercise as remedy is, for example, the right of avoidance. If he has no longer an interest in the contract because he will not receive the goods on time, he can simply, what do you call it in common law countries, repudiate the contract and cancel the contract. And also he is the remedy of suspension, withholding performance would be of course there for that party. In cases of hardship, the remedies available under 79 would be the same. Sandra, who will follow this presentation, will explain that there is a big difference between the remedy of exemption for damages, which is what the CISG provides for, and the remedies stipulated in the unilateral principle. So in conclusion, as I don't have much time and I'm ready to answer any questions you have, COVID-19 has changed the circumstances under which many contracts were concluded. And in order to see whether a party would be exempted from performing, we need to have a look at the contract clauses that may be in the relevant relationship. Otherwise, whenever the CISG is applicable, that is in many times applicable, unless the parties have excluded their application, the remedy provides a suitable rule with 3 requirements, clear requirements that have or lead to specific remedies that would be suitable for today's world. Thank you.
Thank you very much. Our next presenter will be Sandra Friedrich. It doesn't look like the PowerPoint insertion is going to work, so we'll just go with the verbal presentation. If you have any questions, please, what I would recommend is that you present them in chat, and we will also have a time afterwards to deal with them as well. Okay, thank you very much.
Thank you, John. As John said, I'm going to focus on the solutions for force majeure and hardship situations under the UNIDROIT principles. Generally, as many of you, I'm sure, oh, there we have, I see a PowerPoint now. As many of you will know, I'm sure, the UNIDROIT principles of international commercial contracts, the most recent version dates back to 2016, so fairly recent. They're generally considered a non-binding codification or a restatement, if you want, of the general part of international contracts law. However, they can be selected by the parties to govern their contracts, so they can be binding in that sense. And they can also apply as general principles of law. So anywhere where the parties have subjected their contract to lex mercatoria or general principles of law that govern international commercial contracts, the court or tribunal might very well look to the UNIDROIT principles. They're also used at times to interpret other instruments of law, like the CISG, like Edgardo mentioned, and also domestic law. The 2 provisions that I want to focus on, and John, if you could advance one more slide, actually one more, sorry. Yes, perfect. The 2 provisions that I want to focus on are the force majeure provisions, which are found in Article 717 of the UNIDROIT principles, and this excuses non-performance. And on the other hand, the hardship provision in Article 622 and 623 of the UNIDROIT principles, which triggers renegotiation obligations. It's important to note that the current COVID-19 pandemic, contracts might well trigger both of these provisions. And so it's really for the party invoking the provision to decide which remedy to pursue. And next slide. I put on the next slide for you the language of the force majeure provision. If we could advance the slide deck one by one slide. Which you'll see if you've been looking at Article 79 of the CISG, as Edgardo was talking, you'll see that this provision in Article 717 is actually very, very similar to Article 79, with the important distinction that this actually mentions specifically the term force majeure, which Article 79 does not. This was deliberate because the UNIDROIT principles are not meant to be a rival in any way to the CISG, but rather an ally when it comes to international commercial transactions. Now, the force majeure principle here, the force majeure term, was chosen specifically because it's a very familiar term in international contracts, because there are a lot of force majeure or hardship clauses that are included in contracts as a matter of business. Force majeure here is actually found in Chapter 7. As you can see, the first number, Article 7, is Chapter 7, which is the chapter on non-performance, because force majeure basically means performance is impossible. So whether or not it will eventually be excused, it is an issue of non-performance that either will be excused or will give rise to damages. I don't want to go over the elements specifically again, because like I said, it is very similar to Article 79 of the CISG, and Edgardo has already given us a very nice overview. So I just want to make a few comments here with regards to certain points. I believe that the foreseeability analysis with regards to force majeure events will be very important when it comes to determining whether the force majeure provision is triggered here with regards to COVID. And I just want to remind everybody of the timeline that we have, because I think it'll be very important to place the contract in question on the timeline to see how to best present your arguments. What we know so far is that, so back in December of 2019, the first cases surfaced in China into January of 2020. Now, we now know, according to the latest reports, that there might well have been cases in France, even Seattle, as early as December, but it doesn't really matter for the foreseeability analysis what we know today. There's no, hindsight's always 2020. So for the foreseeability analysis, it matters what the parties could have and should have foreseen at the time of the conclusion of the contract. So we have to put ourselves in the shoes of the parties when they concluded the contract. It's also important to note that on January 30th of 2020, the WHO declared a public health emergency of international concern. So in other words, on January 30th, the world started to realize that things are getting serious. This is only the 6th time in the history of the WHO that such a public health emergency was declared. And then by mid to late February of 2020, I think it would be difficult to argue that, generally speaking, the COVID-19 pandemic was unforeseeable at that time, because it started to spread into Europe, it started to spread throughout Asia, and also into the Americas. However, that does not mean that your force majeure claim is necessarily precluded, because there still remains an argument that the exact measures that governments adopted in order to respond to the public health crisis were unforeseeable. So the way that courts and tribunals will define the specific trigger event is really going to be very important when it comes to the analysis of foreseeability. Are we speaking about a pandemic in general? I think we would all agree that even before December of 2019, a pandemic generally was within the realm of possibilities. Even just in the last 20 years, we had the swine flu, we had MERS, we had SARS, we had Ebola, and none of them obviously had the same global proportions that COVID-19 has. But under a broad definition of a trigger event, just as pandemic, it's very easy to argue that this was in fact foreseeable. Now, on the other hand, if we define the trigger event very narrowly, was it foreseeable that a novel type of coronavirus was going to spread around the world and wreak havoc the way that it has, I think that that very much was unforeseeable. I think outside of the medical community, we can all agree that before January of this year, we had never heard of coronavirus. So it's most likely that courts and tribunals are going to adopt somewhat of a middle ground with regards to defining the trigger event. So probably something along the lines of, was it foreseeable that there would be a rapidly developing pandemic with seriously disruptive effects during the lifetime of the contract? And that's also going to be important. It's obviously going to be more reasonable to foresee a certain pandemic event in a contract that maybe lasts for 20 years versus a contract that is supposed to be concluded within the next few months. So all those considerations will be important when it comes to the foreseeability analysis under the force majeure provision. Of course, there also has to be a causation link. So just because there's a pandemic, it doesn't mean that performance is necessarily excused. It has to be because of the specific trigger event. So in parties, I think would be well advised to specifically plead and outline the specific government measures, for example, that led to an inability to perform, like airport closures or travel bans or social distancing measures, industry shutdowns, things like that. I think that the more specifically those arguments were presented, the more likely will be the success. Now, one important difference, and we didn't see the provision of Article 79 of the CISG, but I just want to point out that the CISG actually specifically addresses the force majeure impediments along a supply chain, including third parties that are not under the control of the seller, for instance. Now, the Unavoidability principles do not specifically address that situation, but it's generally accepted that force majeure would have to exclude not just the obligation of the immediate supplier, but also of any other supplier in the upward chain for the party to be able to claim force majeure. Now, also similar to the CISG, there is a specific provision on a temporary impediment, and that's not much different from the CISG, so I'm not going to specifically address that, and instead I'm going to go ahead and jump to the next slide, where we're going to see that the party claiming force majeure is also required to give notice. This again is very similar to the solution adopted in the CISG, so I won't specifically go into it. Now, one of the differences that Edgardo already mentioned is that the CISG does not specifically spell out the actions that might remain available to the other party. However, the Unavoidability principles do so. So the Unavoidability principles are very clear that force majeure will excuse performance, so also specific performance will no longer be available. But on the other hand, the other party is still free to exercise certain rights, including to terminate the contract if it's a fundamental non-performance, including withholding its own performance, and including requesting interest on any money that is due. So the Unavoidability principles here are a little bit more specific in that regard. I also wanted to mention that in cases of temporary impediments, usually the result is an extension of the time to perform, but the length of the impediment is not necessarily going to be the same as the length of the extension. So for example, in construction projects, you could see that in certain areas of the world, construction is only possible during certain times of the year, for example, not in winter. So if a 1 month delay on construction now pushes the contract into the season where construction is not possible, the extension to perform would usually not be just the 1 month, because that's going to be pointless, but could well be up to 6 months, giving the party time to perform in the new season. And with that, I want to jump to the hardship provision of the Unavoidability principles, which is on the next slide. And this is really the most important distinction, because as Edgardo mentioned, there is no explicit hardship provision included in the CISG. Now, with regards to the Unavoidability principles, the hardship provision is found in Chapter 6 rather than Chapter 7. Chapter 6 deals with performance issues. So hardship basically means that while performance is technically possible, it is overly burdensome and therefore should be dealt with under the chapter of performance. Now, it is disputed whether or not the UNIDROIT principles can be brought into the CISG under Article 7 as general principles of law to provide the hardship standard. So, that's a very much a disputed issue. Now, with regards to the hardship provision in the UNIDROIT principles, of course, if the parties specifically selected the UNIDROIT principles to govern their contract, this is very much of mandatory application. And you see here that hardship is defined as an occurrence of events that fundamentally alter the equilibrium of the contract. This is a legal concept that's not unfamiliar to many of you, I'm sure. So it's very much known in other legal systems, and I'm just gonna quickly go over this because I know that we're nearly out of time and we have to stick to a strict schedule here. I want to just kind of highlight some of the points here. For example, fundamentally altering the equilibrium. There is no specific threshold. So for example, if it's become 50% more expensive to perform the contract, that in and of itself is not necessarily guarantee a hardship claim. Case law on that is all over the place. So that is not in and of itself enough. And if we go to the next slide to finish up, I want to point out that the remedies for hardship are very different from the CISG because hardship, first and foremost, entitles the disadvantaged party to request renegotiations of the contract so that the contract can be adapted in order to eliminate the hardship. And if such renegotiations fail, either because one of the parties is unwilling to participate or the parties both participate in good faith but come to no conclusion, then it is a matter for the court to decide how to proceed, and courts may then terminate the contracts or may adapt the contract in order to redistribute the risk of the hardship to both parties. Courts can also order parties to go back to negotiations, or courts can also confirm the contract terms as they are and order the parties to proceed. And to conclude, on the next slide, and I know Edgardo had also addressed this, these statutory provisions under the UNIDROIT principles, of course, only come into play if the parties have not specifically agreed otherwise in their contract, and many commercial contracts do include specific force majeure and hardship provisions, including the ICC clauses, which actually specifically include the term epidemic under presumed force majeure events. So there is a very good chance that COVID-19 being a pandemic, so an epidemic of global proportions, will fall under many contractual hardship provisions. And I think with that, we'll hand it back to John.
Sandra, thank you very much. Now we have looked at the issue from the point of view of the CISG and Lex Mercatoria. Rose is now going to address the treatment of force majeure in a national system, in particular focusing on the recent changes to the French Book of Obligations, which I believe went into effect in 2016. So I won't take up any more time, Rose, so if you want to proceed, I will move to your slide and you can begin your presentation.
Good morning, thank you, John. The beauty, I guess I would say the disadvantage of going last is dealing with everybody saying everything that's you're supposed to say. So I will try my very best not to repeat what Sandra and Edgardo had already mentioned, but I have to say it's very difficult because the French force majeure clause, I would say, under the civil law is like, I would say it's a combination of what both Edgardo and Sandra has articulated for us this morning. Just to mention, we all know that force majeure deals with the supervening unforeseen events that make performance impossible. And force majeure has been defined as being superior force, act of God. It can cover things such as flood, fire, droughts, earthquake, civil riots, terrorist attack, and now 2020 would say maybe pandemic. So the thing about force majeure in France, for many years, it was never defined. And we're gonna see this under the article you have here. That's the old article 1148 in the French Civil Code. And I have to make a disclosure that these are not perfect translation, because Légifrance actually has a disclosure saying it's not intended to give legal advice, but just for knowledge sharing. So whatever translation I've provided now, you know, it's not something you can rely on. If you have a case in French court, it would be highly advisable to get your translator to give you the perfect translation. So let's look at Article 1148. It says basically damages are not due when, because of a force majeure or a fortuitous event, the obligor or the debtor either was prevented from giving or doing what he was obligated to give, or did what he was forbidden to do. So as a practitioner, you read this, you start laughing, because you're like, what the heck is this force majeure? There is no definition. For many years, we see that courts and tribunal, they had to develop the term, and that's how they come up with different definition of force majeure. And you can see that through the cases that were decided. But in 2016, like you've said, John, droit des obligations, the French legislature has decided enough is enough. We're going to now clarify what is force majeure. So what they did, they inserted article, if you can move to the next slide.
Yes.
And my only slide. Article 1218 of the Civil Code, they inserted this new article to finally define force majeure. So my presentation will be first on the first paragraph of the translation here, which you should not rely on, is just for purpose of this presentation. And it defines force majeure, and it also gives you those tests, I would say perfect tests that both Edgardo and Sandra has mentioned to all of you this morning. And the second part is the remedy, which Sandra has also covered in terms of whether the impediment is temporary or permanent. So now let's go by the very first one. It says here, there is force majeure in contractual matters when an event beyond the control of the debtor, that's test one, it has to be an event. The event has to be external, and it has to be beyond the debtor's control, and which could not have been reasonably foreseen. There we go now. Second test is the foreseeability factor. And then it has to be the foreseeability, just like Sandra mentioned, at the conclusion of the contract. So you cannot wait when litigation or before the tribunal is when you're gonna argue you did not foresee this. It has to be way when you are signing the contract, and whose effect cannot be avoided by appropriate measure. So basically you can't perform at all. And final test is that it prevents performance of the debtor. So you have to show, one, that it was unforeseeable. You have to show, one, it was beyond your control through an external factor. Then two, that you could not have foreseen it. And three, you can't perform. And four, that there was a causation, and that causation is not a proximate causation, is a direct causation. So when you look at force majeure in France, we can say that clearly it was designed to cover Article 79 of the CISG, and also take into consideration the unidroit principle, as Sandra explained earlier. So the externality, I would say, factor, the occurrence of an external event for which the debtor has not assumed the risk. Because if you assume the risk, then you cannot claim force majeure. And also the second test is the unavoidability, or you would say irresistibility. The occurrence of the external event was beyond the person's control, or the sphere of your control. You have to prove that as well. And the third one, you have to prove that it was not foreseeable at the time that you signed the contract. The debtor did not foresee the consequences or adverse effect of the impediment, or could not reasonably have been avoided. And then last, the causation is a but-for test, not the proximate causation. It has to be like the debtor's non-performance was as a matter of commercial reality that caused by the external event and not by his own fault. So no assumption of risk, and it has to be a but-for test. So now if you go with the second part of the Article 1218, which is the impediment, it says this: these are the remedies you can get. If the impediment is temporary, performance of the obligation is just suspended, unless the delay, I would say, which result justified termination of the contract. Now, put it in context. In COVID-19, many respondents, I would say, who are claiming no force majeure if they miss delivery, they are going to argue that the impediment was a temporary impediment, because WHO and all the experts says after 18 months, things will get back to normal, we'll get a vaccine. So this is up for discussion. And just like Sandra said earlier, but if you can prove waiting 18 months is going to fundamentally alter the purpose of the contract, and maybe you can still get your force majeure clause to be effective. But the bottom line is, under French laws, they look at the impediment. And especially with regards to, outbreaks, they are very strict as to whether or not is it foreseeable. Shouldn't you foresee there was always going to be a pandemic? We saw one, and we don't know exactly when it was going to happen, but maybe it was always foreseeable. So that's also up for discussion there. And then if, according to Article 1218, if the impediment is actually permanent, and what it does, the contract is terminated by operation of law. So that's the term that we call, you become free from the contract with both seller and buyer or debtor and obligor. They can just shake hands, find someone else to do your contract with, and no problem, no damages. And in putting this in the context of COVID-19, I think it's very, very important to make the difference between force majeure and hardship clauses, because force majeure, it has a greater, you have all these tests you have to prove. Meanwhile, the hardship, if you sign on to a contract in year, I don't know, 2014, and it used to be $10 per barrel or whatever, and then now coming with COVID, it's now 20, it's twice as much. Of course, it's a hardship, because financially you may not be making a profit anymore, but nothing is going to stop you from performing. You can buy it at a higher price. And just like Sandra mentioned, it's always up for renegotiating the contract, but that doesn't mean you can claim force majeure for that. And secondly, put it in context for COVID-19. We're gonna look at governments who have decided which business is essential, which are not essentials. All that is going to affect whether or not you can really claim hardship or force majeure. So if your government decided that your business during COVID-19 was essential, so arguably you did not really lose much, because you were kept open, you keep on serving, and you keep on collecting money. Whereas the other guy who may have been declared deemed non-essential was out of business totally. Going back to the impediment, which is like under Article 1218, the new Article 1218, clearly it shows that if the impediment is temporary, then you can have a suspension. And I said in terms of COVID-19, we can see respondents arguing before tribunal that it was not a permanent impediment, in that WHO and other health organizations, they've said, okay, we'll have a vaccine within 18 months. And covering back what Sandra says, if you can prove that such impediment still will alter the meaning of the contract or make it so difficult for you to perform, maybe you can still go under force majeure, but that needs to be proven. On the other hand, if it's a permanent impediment, clearly you walk away from the contract. It's called effet libératoire. Voilà.
All right. Thank you very much. We have a bit of time left, I think maybe 10 minutes, I believe, for questions.
Yes, John, I think the panelists can ask, and those who are not able to speak can put their questions in the chat room.
Okay. There is, from one of the participants, let's see. Please repeat essential versus non-essential fine points. Thank you.
I've explained under French law, there was the old article 1148, which did not define force majeure. And then versus the new article 1248, I believe, which is inserted now, defines force majeure, gives you those two steps. So now with regards to the impediment, I explained that if the impediment is temporary, then the contract will be just suspended. If it's permanent, then you walk away free from any obligation. Now, with respect to the essential, I was putting in context COVID-19, because some governments have decided, okay, your business is now non-essential versus essential.
Right.
A restaurant during COVID-19 was shut down, closed. You can't go inside a restaurant. However, then now what we see some of the restaurants had to do, they had to change the way that they had to now become like supermarkets, for instance.
Right.
So going back to what Sandra explained, if you have mitigated your loss, all that will be factored in. But if it's totally non-essential, where you could not have opened at all, then I believe both tribunals in court, they will be looking at that, whether it was just a simple hardship, whether it's clearly force majeure.
Perfect. Thank you very much. I'm looking to see, was another question that said it would be good to express the difference between reasonably unforeseeable versus unforeseen as a test for an allowable impediment. I think that question may have been presented during Edgardo's presentation, I believe, but I'm not sure.
I could try to answer. Yes, the last version of the ICC clause included the term reasonably foreseeable, and the CISG also includes reasonably expected. It seems that the inclusion of such a term would lower the standard, but to be honest, even in those, if you put yourself in the position of any adjudicator, judge, arbitral tribunal, even if the word reasonably is missing, most of the time you will see whether the event was unreasonably foreseeable or not, or expected. Sure. Rose just mentioned, well, there were pandemics before, but could we reasonably expect that pandemic was this pandemic COVID was going to really cause all these changes in circumstances? I would say no. And even if the term reasonably is not there, even if only unforeseeable or unexpected is there, most of the adjudicators would say we could not reasonably expect that we will have a new pandemic of this scale. That would be my answer.
John, with your permission,
of
just
course.
A question to Rose, Sandra, and Edgardo. The word reasonable is usually there to import some sort of objective standard. But as those of us who grapple with contracts know, when it comes down to the interpretation, there's always some tension between objective factors and subjective factors. And very often the tribunal or the judge says that by looking at each situation in its own circumstance, and that's code for importing something subjective. How do you grapple with that in relation to the provisions that we have just reviewed?
Responding to Edgardo's comment, he believes that a tribunal is likely to see that it was not foreseeable. I think I beg to differ. I think it will be on a case-by-case basis, and it's going to be what kind of business we're looking at. If it's a business that is pharmaceutical, I don't know. It depends on what's before the tribunal. That's number one. And going back with what Mr. Samuda mentioned regarding the objective factor, and I think that's why, in terms of the French Civil Code, we don't look at causation being a foreseeable. We look at it but for, which is like a direct impediment. Then that's how you can really measure the objective factor under the French Civil Code. Because if we do any other tests for the causation, anybody could fall under it. But if we look for a direct causation, it's going to be much tougher.
With regards to the standard, yes, it's primarily an objective standard of was it reasonably foreseeable. But of course, it will very much depend on the situation that the parties are in. For example, I think parties of China, arguably, it was reasonably foreseeable that COVID-19 would affect the contract earlier than it would have been reasonable to foresee that for parties in Europe or parties in the Americas. So subjective considerations, I think, certainly come in, but at the base, it's an objective standard. I also want to point out something with regards to Rose's presentation. It's very important to note that even though the terms that are used are the same, force majeure, I spoke about force majeure under the UNITRA principles, and Rose spoke about force majeure in France, and it's the same term, but that doesn't necessarily mean that the concepts are the same. For example, Rose explained that under French law, basically, if there is a permanent force majeure event, the contract is immediately terminated. That is not the solution under the UNITRA principles, where merely non-performance is excused and the other party remains free to either terminate the contract or suspend its own performance. So the fine nuances of the specific principle that applies is still very important. So while there are overarching similarities between the CISG, the UNITRA, and the specific domestic solutions, I think it's very important to be specifically looking to the governing law or the contractual provision. And I think also with regards to foreseeability, I think this is very much going to change what's foreseeable in the future. I think future analysis will differ after we've gone through this pandemic.
I would also note that in the chat there are two recent questions to all of the panelists, and the questions are a bit long, so I'm not going to read them. But I think the second one is more addressed to Sandra.
I have a question here from Marguerite that says, "What's the difference between force majeure and hardship?" So I would say, very simply put, force majeure means that performance is impossible, whereas hardship means that performance is still possible, but really overly burdensome. So I think that's like a very, obviously very, very simplistic, but I think that's the major distinction. Force majeure is impossible. With hardship, it's still possible, but very, very difficult or overly burdensome with regards to the economics of the transaction.
Okay, and then I think that there is the, I guess, Mr. Isaac's question to you as well.
So the question is, would force majeure, would the COVID-19 pandemic be considered a force majeure event in a commercial lease agreement, which contains a vague, broad force majeure clause that does not specify force majeure events? Yes. So in my opinion, I think there's a very good argument to be made that a pandemic of this global scale and with this kind of rapid development very much would fall even under a general force majeure clause that doesn't specify epidemics or pandemics or global health emergencies specifically. Now, of course, if you have a contractual clause that specifically excludes international calamities or global health emergencies, then that would be different. But a broad clause, even if it doesn't specifically mention epidemics, I think there's very good argument to be made that this qualifies.
Okay, and then I see that there is in the question and answer, I think it is Ms. Card.
I could very briefly answer. Of course, the starting point to look at whether one party should be exempted from any type of impediment or hardship will be the contract. What I'm not sure or may not agree is with the proposition that the clause should be interpreted subjectively, taking into account the circumstances of the aggregated party. That would depend much on the applicable law we apply to interpret the hardship clause. If it is a CISG, the first standard is subjective, Article 8.1, but under the condition that the other party could not have ignored the intent of the party proposing one interpretation. The second standard of interpretation under the CISG Article 8.2 is of the reasonable man that Mr. Milton Sudama has already mentioned. So we would interpret that clause as a reasonable man would have done it. And the third paragraph of the same provision in the CISG says that every time we should consider the circumstances surrounding the specific contract. So case-by-case basis, as Rose already said.
I'd like to thank the panel. It was just a great experience for me to listen, to learn. And I think I would probably be speaking for everyone else when I say that. And thanks to for the organizers for giving us the opportunity for this forum. And with that, we'll consider this panel to be closed and you can move on to the next. And thank you very much.